In an important development to protect home buyers' interests, the Supreme Court has issued a notice to the centre asking it to frame a model buyer and seller agreement. Now, this notice was issued by the Apex Court in response to a public interest litigation or PIL seeking a direction to all states to enforce this model builder-buyer agreement. Now, the question we are asking today on the Property Show, there already exists a model buyer-seller agreement which was put in place by the Ministry of Housing and Urban Affairs when the RERA Act was implemented in 2016. So, why does the Supreme Court believe that buyers are not protected? Joining me, Sanjay Dutt, MD and CEO of Tata Realty and Infrastructure, and also with us, Hardeep Sachdeva, partner at AZB and Partners. Sanjay, let me come to you first. Most of the big states where real estate activity is concentrated, whether it's Maharashtra, Haryana, Noida, Karnataka, they do have a model agreement for sale in place. Not Noida, but UP. Now, union territories have also adopted the agreement for sale prescribed under RERA by the centre. So, what has happened here? In the PIL, it was said that promoters and builders and agents use manifestly arbitrary one-sided agreements that do not place customer at an equal platform with them, which offends Articles 14, 15 and 21 of the Constitution. So, Sanjay, are we to believe that the model agreement, even though it's been prescribed by state RERAs, has been diluted?
I don't think so, Manisha. I think from the time the RERA got implemented, most reputed developers have got the message loud and clear that the agreement or the approach to customer dealings will have to be altered, and there has to be a far more balanced approach. In fact, most of the reputed corporate developers have always been promoting customer centricity. However, because RERA took time to implement, I think Maharashtra perhaps did the best job of implementing it, followed by a few other states, whether it's Haryana, Karnataka, and Tamil Nadu, and probably the last one was perhaps Kolkata. They've not really come to terms yet to every aspect of real estate, or every aspect of reforms of the RERA that got implemented. And most of the attention got diverted to immediate problems in hand, and that was delivery of the projects. That was the promises made, and therefore the concentration and the entire energy of the machinery set up by state governments got diverted to those. But I believe the agreements today, just to start with, we used to make agreements on super area basis. Now across board, it's now on carpet area. So a lot of transparency has already come in and customer interests are protected. Yes, if we create one model agreement, barring few changes that each state is so unique, and municipal corporation or body which is very unique, right, or the land title which is unique, may take place.
So Sanjay, you're right. A lot has changed after RERA has come into place. But I've also spent considerable time looking at the RERA prescribed agreement for sales in, Delhi, which is a union territory, UP, Haryana and Maharashtra RERA websites, and a few agreements which have been signed post 2016 or state RERA implementation. And I'm going to go through, before I go to Hardeep, I will go through some of the key areas where I found some dilution of clauses. Well, the RERA model agreement says that it must have a mandatory mention of carpet area, and such carpet area shall be in accordance with the RERA definition. Now, what I found is that several agreements, there is no standard or common practice. Agreements still mention super built-up area, saleable area and carpet area, all sorts of terms. Another point, alterations of layout plans, specifications, fixtures, etc. The model agreement stipulates that the developer shall not make any additions and alterations in the sanctioned plans or layout plans without the consent of the home buyers. However, in many of the buyer-seller agreements, the promoter or the developer retains the right to alter or modify the plan of construction without the consent of the buyers. This is an important point. Now, the total price, once agreed upon with the buyer, must be escalation-free, except if there is an increase on account of any development charges payable to the state authority. Again, I find there is no common practice followed in the agreements to sell or clearly mention clause. Now, RERA also says it is mandatory to mention the car parking details. Car parking number, measurement, its location. Now, this clause is very clearly mentioned in the model agreements on state RERA websites. The developers, though, dilute this widely and retain the right to allocate the car parking at a later point of time. It's also clarified in the model agreement that projects, facilities and amenities shall be available only for the use and enjoyment of the allottees of the projects or the buyers. Now again, I find no standard, no common practices are followed. Builders in many cases retain the amenities or clubhouses and other facilities in the projects. Okay, so Sanjay, these are some of the things that I have found. I have really studied the state RERA model agreements and also procured a lot of agreements from different states. Now, these are some of the big gaps that I found. Are you saying that all of the good brands have actually plugged these holes?
Not at all, Manisha. And no, I admire your preparedness on this topic. But let me tell you, perhaps government did not give enough time to really understand how the real estate works. Now, if the municipal corporation decides to change the law and which requires additional shaft to be built in the building for fire dedicated elevators, I am supposed to incorporate and be compliant, Manisha. How can I write that I will never change?
Sanjay, there is a clear clause. I agree with you. There is a clear clause which says if the competent authority makes the changes, then you can make the changes. But in the agreements that I have evaluated, the builder has retained that clause that they have the right to alter. So therein lies the thing. It is not qualified.
I'm coming towards your second point, Manisha. Now, you assume that most of the developments are single tower development. What about developments which are actually a mixed use or a large development which a developer cannot build in one go? They have to be phases. Now, how do I perceive a next 10-year horizon for the entire township and agree with the customer today? And every time there is a change, it's like telling an automobile manufacturer that I will produce X number of cars in this year for next 5 years. It is impossible to do. So we are required to make changes in the plan because the customer needs change, Manisha, not because we want to change. What if the customer now wants more pandemic friendly, work from home friendly, and
so Sanjay, all that you need to do is put in a clause where, I mean, as per RERA, get the buyer's consent, right? But the agreements don't have that. I see them a lot more vague. I'll come to you and I totally take your point. Let me ask Hardeep. I mean, he's obviously represented developers. He's also represented home buyers. Hardeep, do you believe that this kind of flexibility will be required to be offered in these agreements, as Sanjay is saying, keeping in mind the city and state specific development regulations and laws which are likely to impact the projects, especially like he's saying in a pandemic situation, maybe buyers' needs have changed. So how much flexibility does one give in these agreements?
I think I just want to start with the with the case in point where Supreme Court is asking for a model agreement for, in my view, for the entire country. And why do we need that? If I just go back on this one. Now, while living in Delhi, I can tell you one small, very, very important clause or very important provision for the home buyers or the customers in any flat buyer agreement differs from Noida to Gurgaon to Delhi is the quantum of the compensation or the amount of interest that the builder or the developer is liable to pay to the home buyer for the delays in the construction or handover of the apartment. Now Haryana says X, UP says Y, Delhi says Z. So has there been a case made out for seeking uniformity on some of these provisions which are protective for the customers or home buyers across the country? I think yes. That's only one example I've given you. I can give you several examples of how even the bordering states, or how otherwise NCR being a seamless place here, you still have so many different provisions in two states on very important or the fundamental provisions of RERA. Now, therefore, has the case been made out for uniformity? Yes, it is in the interest of the customers to ensure that the developer is not taking out anything beyond what the regulations are allowing in spirit.
What you're saying, Hardeep, were the two sacrosanct clauses of RERA, isn't it? That 70% should be in the escrow account to protect the buyer's interest so that the money goes for construction. And the second part, that the compensation should be determined with the interest rates going in the economy, the current ones, and of course should be equal for the buyer and seller. You're saying even these are not equal across states. All right, we have managed to get Ashwini Upadhyay, BJP leader and advocate who filed the PIL. Let me also ask him, why does he feel that the centre actually, or Justice Chandrachud did ask for that model agreement again from the centre? अश्विनी जी, आपको क्या लगता है कि राज्यों ने बहुत ज्यादा डाइल्यूशन कर दिया है? क्योंकि एक मॉडल एग्रीमेंट तो था। रेरा जब 2016 में आया है तो मिनिस्ट्री ऑफ अर्बन डेवलपमेंट और हाउसिंग ने एक मॉडल एग्रीमेंट निकाला था जो यूनियन टेरिटरीज इस समय कहती हैं कि वो अडॉप्ट कर रही हैं। तो प्रॉब्लम किधर है?
मैं ये कह रहा हूं मैडम कि रेरा जो बना था 2016 में, उसका पर्पज ये था कि ट्रांसपेरेंसी आए और जो चीटिंग हो रही थी बायर के साथ, तो लगातार फ्रॉड हो रहा था, वो फ्रॉड रुके। कुछ तो कम हुआ, मैं ये नहीं कह रहा हूं 2016 के बाद कुछ चेंजेस नहीं आए, थोड़ा बहुत चेंज आया, लेकिन मनमानी वैसे ही चल रही है। बायर्स आज भी परेशान है। बायर्स का जो चीटिंग होती थी कि अगर उनका चेक बाउंस हो जाएगा तो उनसे 18% इंटरेस्ट लिया जाएगा, और पोजीशन जो 3 साल के बजाय 6 साल भी देते हैं तब भी कोई 18% नहीं देते। तो ये जो बिल्डर बायर एग्रीमेंट चल रहा है वो वन साइडेड है, यूनिलैटरल है, और उसमें ऐसे ऐसे क्लॉजेस बना देते हैं कि कॉमन मैन तो छोड़िए, वकीलों को भी बड़ा दिमाग लगाना पड़ता है, डिक्शनरी लेके बैठना पड़ता है, समझना पड़ता है क्या क्या इसमें इंग्लिश लिखी, इतनी हाई फाई इंग्लिश लिख देते हैं। मेरा ये कहना है सेंट्रल गवर्नमेंट एक 5 से 6 पेज का, 8 पेज का या 9 पेज का एक कॉमन यूनिफॉर्म बिल्डर बायर एग्रीमेंट बनाए जो न्यूट्रल हो। अभी का जो बिल्डर बायर एग्रीमेंट है टोटली वो बिल्डर्स के फेवर में है। जो रेरा द्वारा अप्रूव्ड या स्टेट गवर्नमेंट द्वारा अप्रूव्ड भी बिल्डर बायर एग्रीमेंट है, वो भी पता नहीं, मुझे लगता है या तो बिना दिमाग लगाया गया या कहीं प्रेशर में किसी को उसको अप्रूव किया गया है, वो भी आर्टिकल 14 की स्पिरिट में नहीं है, उसमें भी बायर्स के लिए कुछ नहीं है, वो भी एक तरफा है। इसीलिए मैंने इसमें सारे स्टेट्स को पार्टी बनाया है। मेरी पहली प्रेयर है सेंट्रल गवर्नमेंट एक यूनिफॉर्म बिल्डर बायर एग्रीमेंट बनाए। दूसरी हमारी मांग है स्टेट गवर्नमेंट इसको इंप्लीमेंट करे। जो क्लॉजेस होने चाहिए वो दो तरफा हो। अगर चेक बाउंस होने पे 18% तो पोजीशन डिले होने पे भी 18% ब्याज के साथ मिलना चाहिए बायर्स को। हमारा ये कहना है।
आपने अपनी बात काफी स्पष्ट कर दी है। थैंक यू हमसे जुड़ने के लिए और अपनी जो आपने दलील पेश की है सुप्रीम कोर्ट में उसे समझाने के लिए। Hardeep, what I need to understand from you is that, look, what Ashwini is saying is that state RERAs have diluted to some level. I think we can say maybe state RERAs have taken both sides into consideration and made it. But the more important question here is that a buyer today will go and sign, whether it's 25 pages or 50 pages. I spoke to one of the RERA former chairman and he said that if the buyer doesn't come and lodge a complaint that the agreement is not in compliant with the model agreement, how are we to take action against the builder?
Absolutely. I think I'll just say, one thing is that I do not think I agree with the gentleman that the present agreements are one-sided agreements. And I said that earlier as well, that I think the case has been made out to have more uniformity in these agreements across all states in India. As I mentioned earlier about the interest payments, and there are more clauses that needs to be ironed out for each and every state, for every customer there. That is point well taken. But the second part, where people are saying that there is a non-compliance of RERA regulations or RERA Act by having a different provisions in the flat buyer agreement by the builders, I don't think that you need to amend your agreement for that. I think the recourse is very well available for every customer to just go and file a complaint against that developer for a non-compliance before a RERA authority. They will take action against such developer who are not following the written provisions or the required provisions of the RERA regulations. That you don't need that to have a case for a model agreement throughout the country. I think to have a case for a model agreement throughout the country is that how we need to have the equal amount of protection given, or the same protection given or extended across all customers, all citizens in this country, across all states.
Hardeep, you've made your point. Sanjay, would you agree with it that at least the discrepancy which Hardeep has mentioned, that between Delhi, Haryana and Noida, there are so many differences in the agreements prescribed by the 3 different state RERAs, that should at least end?
So, Manisha, first of all, it's a good initiative. There can be a model agreement. It can be a guidance. However, given the diversity and federation of states in the country, it will be difficult to implement. Even the municipal governments will struggle and the RERA authority will struggle. The second point, Manisha, I want to make, every buyer makes the biggest investment of their life in their home purchase. Why can't they read the agreement properly? One, why can't they avail the services of a competent lawyer to help them understand the agreement? Why can't they, instead of saying you make a simple agreement which I don't have to read, sign and my interest should be protected, simply because they don't want to read it. It's a wrong thinking.
Well,
Manisha,
in this country where there's also the problem of how financially literate home buyers are. Sanjay, but point taken. We've completely run out of time, but thank you so much for joining us for this discussion. I don't think this conversation is going away anywhere in a hurry. So while we wait for the centre to come out with directives to all states to follow the model agreement for sale, as Sanjay has pointed out, and the lawyers will also tell you that you as a home buyer should understand your rights, read all the clauses carefully, and if you don't have the patience, take it to a lawyer before you sign on the dotted line. When we return, a look into the 1 lakh square feet India Pavilion at Dubai Expo and what went behind that grand design which is making waves.